The doorbell rang at exactly 7:45 in the morning, which was already my first clue that something irritating was about to happen. Normal people don't show up uninvited before 8 on a Saturday unless they are either lost or looking for trouble. I was halfway through my second cup of coffee, still wearing my old fire department sweatshirt and gym shorts, when I opened the door to find Patricia Henderson standing on my porch with a clipboard, a pinched expression, and the kind of blazer that screamed, "I need to speak to your manager." "Good morning, Mr. Donovan," she said, her voice clipped and formal. "I'm Patricia Henderson, the president of the Meadowbrook Estates Homeowners Association. We need to discuss a serious violation on your property." I took a long sip of my coffee and leaned against the doorframe. A violation. What kind of violation? Patricia's perfectly manicured finger pointed toward the fire hydrant at the corner of my yard, right where my property line met the sidewalk. That hydrant. According to HOA Regulations Section 12.4, all fire hydrants within the community must maintain a clearance zone of 15 feet in all directions. Your landscaping is encroaching on that zone by approximately 3 feet. I glanced at the hydrant. I'd lived in this house in Oakdale, Oregon for 6 years now, and that same patch of ornamental grasses and native wildflowers had been there since, before I moved in. The previous owner had planted them specifically because they were low maintenance and drought resistant. They were maybe 2 feet tall, nowhere near blocking access to the hydrant. "Those are just ornamental grasses," I said. "They don't interfere with the hydrant at all." Patricia's lips pressed into a thin line. "The regulations are quite clear, Mr. Donovan. 15 feet of clearance. I've already issued citations to 3 other homeowners this month for similar violations. I expect full compliance within 7 days, or you'll face fines of $50 per day until the issue is resolved." Something about her tone made my jaw tighten. I'd dealt with plenty of difficult people in my 20 years with the fire department, but there was something especially grating about someone wielding HOA bylaws like they were actual laws. And who exactly determined that 15 feet was necessary? The HOA board, of course. "We take fire safety very seriously in this community." "Fire safety," I repeated slowly. "Right. I'm glad you understand the importance," Patricia said, making a note on her clipboard. 7 days, Mr. Donovan. I'll be back to verify compliance." She turned on her heel and marched down my driveway toward her pristine white Lexus SUV. I closed the door and returned to my kitchen, shaking my head. My wife Rebecca had already left for her shift at the hospital, so I couldn't even vent to her about the absurdity of the situation. Instead, I pulled out my phone and did something I probably should have done before buying a house in an HOA community 6 years ago. I actually read through the entire HOA covenant. It took me about an hour to work through all 47 pages of dense legalese and petty regulations. There was indeed a section about fire hydrant clearance, but the wording was interesting. It said that clearance zones should be maintained in accordance with local fire department standards and recommendations. There was no specific mention of 15 feet. That appeared to be Patricia's own interpretation. Monday morning rolled around, and I drove to the fire station still thinking about the interaction. I'd been the fire chief of Oakdale for 3 years now, promoted up from battalion chief after Chief Morrison retired. It was a good job in a good town, population around 45,000, big enough to keep us busy, but small enough that you still knew most of the business owners and city officials by name. "Morning, Chief," said Miguel Santos, one of our engine operators, as I walked into the station. "You look annoyed." "HOA trouble," I said, pouring myself a cup of the station coffee, which was somehow both stronger and worse than what I made at home. "Say no more," Miguel laughed. "My sister lives in one of those neighborhoods. She got fined because her mailbox was the wrong shade of black. Not a different color, the wrong shade." I spent most of the morning catching up on paperwork and reviewing our response times from the previous week. We'd had a decent week, actually. 2 medical calls, 1 minor kitchen fire, and a false alarm at the high school. Nothing too dramatic. Around 11, I got a call from Tom Chen, who worked in the city planning department. "Hey, Brandon," Tom said. "I got a weird request this morning and wanted to run it by you." Patricia Henderson from the Meadowbrook Estates, HOA, is asking for official documentation about fire hydrant clearance requirements. She says she needs it for enforcement purposes. I sat up straighter. "What kind of documentation?" "She wants something in writing that says fire hydrants need 15 feet of clearance in all directions. I told her I'd check with you first since that's really your department's jurisdiction." "Good call," I said. "The actual requirement is 3 feet of clearance, Tom. 3 feet, not 15. And that's just to ensure we can access the hydrant connections and operate the valves. There's nothing in the fire code that requires 15 feet. "That's what I thought," Tom said. "She was pretty insistent, though. Kept saying it was a safety issue, and that the HOA had the authority to set stricter standards than the city. The HOA can set whatever standards they want for things like fence heights and paint colors," I said. "But fire safety standards are set by the fire department and the state fire marshal's office. If she's going around telling people that 15 feet is the requirement and claiming it's for fire safety, that's a problem." "Want me to tell her that?" "No," I said, an idea forming. "Forward me her contact information. I'll handle this directly." Tom sent over Patricia's email address and phone number. I decided to start with an email, keeping it professional and official. I identified myself as the fire chief, explained that the actual clearance requirement for fire hydrants in Oakdale was 3 feet, and noted that the fire department had not been consulted about any HOA regulations regarding fire hydrant access. I attached a copy of the relevant section of the Oregon Fire Code and hit send. The response came back in less than 20 minutes. "Chief Donovan, thank you for your input. However, the Meadowbrook Estates HOA maintains higher standards than minimum city requirements. Our 15-foot clearance zone is well within our rights to enforce. The covenant gives the HOA board authority over all matters of community safety and aesthetics. Regards, Patricia Henderson, HOA President." I read the email twice, feeling my blood pressure rise. She'd completely dismissed the actual fire safety expert and was hiding behind HOA bylaws. I picked up the phone and called her directly. Patricia Henderson speaking. "Mrs. Henderson, this is Chief Donovan from the Oakdale Fire Department. I wanted to follow up on my email." There was a pause. "Oh, Mr. Donovan, I didn't realize you worked for the fire department." "I don't work for the fire department," I said. "I'm the fire chief. I run the fire department. And I'm telling you that your 15-foot clearance requirement is not based on any actual fire safety standard. It's excessive and unnecessary." "Well, I'm sure you understand that the HOA has the right to set standards that exceed minimum requirements," Patricia said, her voice taking on that same clipped tone from Saturday morning. "We're simply being proactive about safety." "You're being proactive about something, but it's not safety," I said, trying to keep my voice level. "The 3-foot standard exists because that's the amount of space we need to physically access the hydrant and connect our equipment. Anything beyond that doesn't improve safety at all. It's just arbitrary." "I disagree, Chief Donovan, And unless you can provide documentation that our standard is somehow illegal, the HOA will continue to enforce it. Mrs. Henderson, I'm the authority on fire safety standards in this city. I'm literally the person who decides what the fire safety priorities are here. If I tell you that 15 feet is unnecessary, then it's unnecessary. Your opinion is noted, Patricia said, but the HOA board has already voted on this policy. Now, if you'll excuse me, I have several other homeowners to contact about violations. Good day, Chief Donovan. She hung up before I could respond. I sat there staring at my phone, genuinely stunned. In my entire career, I'd never had someone so completely dismiss my professional expertise, especially on something directly related to fire safety. City council members listened to me. The mayor listened to me. Even the county commissioners deferred to my judgment on fire-related issues. But Patricia Henderson, armed with nothing but an HOA covenant and an inflated sense of authority, had just blown me off like I was some random homeowner complaining about a parking ticket. Miguel stuck his head into my office. Everything okay, Chief? You look like you're about to bite through your coffee mug. I'm fine, I said. Just dealing with someone who thinks HOA bylaws override actual fire codes. Yikes, Miguel said. That's the same HOA that's bugging you about your yard, the very same. Well, if it helps, we got called out to Meadowbrook Estates last month for a hydrant that wouldn't open properly. The valve was completely seized up. Took us 15 minutes just to get water flowing. That got my attention. Which hydrant? The one on Maple Grove Drive, near the park entrance. Probably hadn't been maintained in years. I pulled up our maintenance records on the computer. Miguel was right. That particular hydrant had failed its last inspection, which was over a year ago. There was a note that the City Public Works Department had been notified, but I didn't see any follow-up indicating the issue had been fixed. This is interesting, I murmured. What are you thinking, Chief? I'm thinking that if Patricia Henderson is so concerned about fire safety, maybe she should be worrying about hydrants that don't actually work instead of ornamental grasses that don't affect anything. The next morning, I assembled my team for our quarterly hydrant inspection. We did this 4 times a year, going through the city section by section to make sure every hydrant was functional, properly maintained, and accessible. It was routine work, but it was important. A hydrant that doesn't work when you need it can mean the difference between a contained fire and a total loss. We're starting with Meadowbrook Estates today, I told the crew. I want every single hydrant in that development checked and documented. Flow rates, valve operation, paint condition, visibility, and clearance. Everything. That's pretty thorough, Chief, said Jennifer Walsh, one of our newest firefighters. We usually just do the basic operational check. Today we're being extra thorough, I said. Trust me on this. We loaded up Engine 3 and headed out to Meadowbrook Estates. The development was one of the newer ones in Oakdale, built about 8 years ago during a growth boom. It had about 200 homes, all in that modern craftsman style that was popular, with HOA-mandated earth-tone paint schemes and professionally landscaped common areas. Very neat, very tidy, very regulated. The first hydrant we checked was on Willow Creek Lane. Paint was faded, valve operated smoothly, clearance was adequate. I had Jennifer document everything with photos and notes. The second hydrant on Birch Street had some corrosion around the connections but was otherwise functional. The third hydrant, the one on Maple Grove Drive that Miguel had mentioned, was exactly as bad as the records indicated. The valve was seized, and when we finally got it open with a wrench and some leverage, the flow rate was about 30% of what it should have been. This one needs to be red tagged, I said. It's not reliable enough for emergency use. We continued through the neighborhood, checking all 18 hydrants within the Meadowbrook Estate's boundaries. Of those 18, 5 had significant issues ranging from poor water pressure to seized valves to faded paint that made them less visible. 3 of them, including the one on Maple Grove Drive, were bad enough that I marked them as non-serviceable until repairs were made. But here was the interesting part. None of the hydrants, not a single one, had any actual clearance issues. Sure, some had landscaping nearby, including mine, but nothing was blocking access to the connections or preventing us from operating the equipment. The clearance wasn't the problem. The maintenance was. "So what's the deal, Chief?" Miguel asked as we finished up. "Why the deep dive on this particular neighborhood?" "Because the HOA president is running around threatening people with fines over landscaping that doesn't affect anything," I said. "Meanwhile, there are actual fire safety issues that nobody's paying attention to. You going to tell her?" "Oh, I'm going to do more than tell her." That afternoon, I prepared a comprehensive report detailing every issue we'd found during the inspection. I documented the non-functional hydrants with photos and technical specifications. I included citations from the Oregon Fire Code about maintenance requirements. I even pulled historical data showing how long some of these issues had been present. Then I sent copies to 3 people: Patricia Henderson, the City Public Works Director, and the Meadowbrook Estates HOA Board Secretary, whose contact information I found on the community website. The email to Patricia was cordial but direct. I explained that during a routine inspection of the neighborhood, we'd identified multiple fire safety violations related to hydrant maintenance. I noted that these were actual code violations, not HOA policy violations, and that they required immediate attention. I also mentioned, in what I thought was a very professional and not at all petty way, that none of the hydrants had any clearance issues that would impede fire department operations. The response came the next morning, and it wasn't from Patricia. It was from a man named Douglas Remington, who identified himself as the HOA Board Vice President and Legal Counsel. "Chief Donovan, thank you for bringing these maintenance issues to our attention. However, I must point out that fire hydrant maintenance is the responsibility of the City Public Works Department, not the HOA. We are not responsible for the operational status of city infrastructure. As for your comments about clearance requirements, the HOA maintains its right to enforce aesthetic and safety standards that exceed minimum city requirements. We appreciate your feedback, but will continue to enforce our existing policies." Douglas Remington-esque. I had to read that email 3 times to fully process the logic. They were claiming they weren't responsible for maintaining city infrastructure, which was technically true, but they were simultaneously claiming the authority to set standards for how homeowners maintained their property around that same infrastructure. They wanted control without responsibility. My phone rang. It was Marcus Webb, the Public Works Director. "Brandon, I got your report about the Meadowbrook hydrants," Marcus said. "This is embarrassing. Some of these issues should have been fixed months ago." "What happened?" I asked. "Budget cuts and staffing shortages, honestly. We're down 2 people in maintenance, and hydrant service got pushed down the priority list. That's not an excuse, just the reality, but we'll get a crew out there this week to start making repairs." "I appreciate that, Marcus, but here's the thing. The HOA is running around fining people over landscaping near hydrants while the actual hydrants don't even work. It seems backward." "You're not wrong," Marcus sighed. "HOAs are weird beasts, though. Legally, they've got a lot of authority over their communities. As long as they're not violating actual laws, They can pretty much make up whatever rules they want. Even if those rules contradict professional standards, even then, people sign the covenant when they buy the house. That's basically a contract saying they'll follow the HOA rules, even the stupid ones. I hung up feeling frustrated. I'd been in public service long enough to understand how bureaucracy worked, but this felt different. This felt like someone abusing a tiny bit of authority just because they could. The 7-day deadline Patricia had given me was coming up that Saturday. I'd made no changes to my landscaping, obviously. I was curious to see what she'd actually do. Right on schedule, at 8 in the morning, Patricia appeared at my door again. This time she had someone with her, a younger woman with a tablet instead of a clipboard. "Mr. Donovan," Patricia said, "as you can see, the 7-day compliance period has expired. Your landscaping still violates HOA regulations. I'm here to officially document the violation and inform you that you'll be fined $50 per day starting today until the issue is resolved." "Mrs. Henderson," I said calmly, "as I mentioned in my email earlier this week, I'm the fire chief. The actual fire safety standard for hydrant clearance is 3 feet, which my landscaping complies with. Your 15-foot requirement is not based on any legitimate fire safety concern." "Chief Donovan," she said, emphasizing my title in a way that somehow made it sound dismissive, "your professional opinion is noted. However, the HOA covenant is a legally binding contract. You agreed to follow these rules when you purchased your home. The board has the authority to enforce them. The covenant says clearance should be maintained according to fire department standards," I countered. "I've read it, and I'm telling you what those standards are." Patricia's assistant held up the tablet, showing me a photograph of my hydrant and the surrounding landscaping. "The violation has been documented. You'll receive a formal notice in the mail with information about the fines and the appeals process." "There's an appeals process?" I asked. "Yes, you can submit a written appeal to the HOA board. They meet on the 3rd Thursday of each month. Your appeal would be heard at the next available meeting, which would be in about 5 weeks. And in the meantime, I'm getting fined $50 a day." "That's correct. The fines incentivize prompt compliance." I could feel my temper rising, but I kept my voice level. "Mrs. Henderson, did you receive my report about the hydrant maintenance issues in the neighborhood?" "I did. And as Mr. Remington explained, those are city infrastructure issues, not HOA matters. But you're fining people over landscaping near those same hydrants that don't work. Doesn't that seem backward to you? The HOA is responsible for maintaining community standards," Patricia said. "The city is responsible for maintaining city infrastructure. These are separate issues." "No, they're not separate. They're both about fire safety. The difference is that one is an actual safety issue and one isn't. The landscaping doesn't affect anything. The broken hydrants could get someone killed." Patricia's expression hardened. "Your fine begins today, Chief Donovan. Good day." They left, and I stood in my doorway, genuinely amazed at the interaction. This woman was going to fine me $50 a day for ornamental grasses that posed zero safety risk, while completely ignoring actual fire code violations in her own community. I called Rebecca at the hospital during her lunch break. "She's actually fining you?" Rebecca asked, incredulous. "Even after you explained that you're literally the fire chief?" "Apparently my expertise doesn't matter because the HOA covenant is a legally binding contract," I said, mimicking Patricia's tone. "That's insane. What are you going to do?" "I'm going to file an appeal. And I'm going to make very sure that every homeowner in Meadowbrook Estates understands what their HOA is prioritizing." "Please don't do anything that gets you arrested," Rebecca said. "I'm going to follow every rule and regulation to the letter," I assured her. "I'm just going to be very thorough about it." I spent that weekend preparing my appeal. I included technical documentation about hydrant clearance standards, photographs showing that my landscaping didn't impede access, references to the Oregon Fire Code, and a detailed explanation of why the HOA's 15-foot requirement was arbitrary and unsupported by any legitimate fire safety concern. I also included, just for good measure, a complete copy of my hydrant inspection report showing the actual violations in the neighborhood. The appeal was 12 pages long when I finished. I sent it to the HOA board via certified mail and email, making sure I had proof of delivery. Then I did something else. I printed out 50 copies of a one-page flyer. At the top, in bold letters, it said "Fire Safety Information for Meadowbrook Estates Residents." Below that, I'd summarized the key points. The actual clearance requirement was 3 feet, not 15. 5 hydrants in the neighborhood had failed recent inspections. 3 hydrants were currently non-serviceable, and homeowners had the right to appeal HOA decisions that contradicted professional standards. I didn't mention Patricia by name. I didn't have to. Anyone who'd been contacted about clearance violations would know exactly what the flyer was about. On Sunday afternoon, I took a walk through the neighborhood and left a flyer in every mailbox I passed. It took about 2 hours to cover most of the development. By the time I got home, my phone was already ringing with calls from neighbors I'd never met. The first call was from a man named Richard who lived on Oak Hill Drive. "Is this Chief Donovan? I got your flyer." "Listen, the HOA sent me a violation notice last month about the bushes near the hydrant on my corner. I cut them back. Cost me $300 to hire a landscaper. Are you saying that wasn't necessary?" "The 3-foot standard means you need to keep the immediate area around the hydrant accessible," I explained. "If your bushes weren't blocking the connections or preventing someone from operating the valve, they probably didn't need to be removed entirely, just trimmed enough for access." "Son of a..." Richard caught himself. "That's really frustrating, Chief. I wish I'd known that before I paid someone to tear out half my landscaping." The calls continued throughout the evening. I heard from at least a dozen homeowners, all with similar stories. Patricia had been on a crusade about hydrant clearance for the past 2 months, and many people had already spent hundreds or even thousands of dollars on landscaping changes that weren't actually necessary. Monday morning, I arrived at the fire station to find an email from Douglas Remington waiting for me. "Chief Donovan, it has come to the board's attention that you distributed materials in the Meadowbrook Estates community yesterday containing information about HOA policies. This distribution was done without board approval and constitutes a violation of community rules regarding solicitation and posted materials. You are directed to cease this activity immediately. Additionally, your characterization of HOA policies as contrary to professional standards is defamatory and harmful to the board's reputation. We demand that you issue a retraction." Douglas Remington-esque. I had to laugh. They were threatening me over flyers that contained factual information about fire safety. I forwarded the email to the city attorney, along with a note asking if they saw any legal issues with what I'd done. The response came back within an hour. As a public official providing accurate information about fire safety to residents, I was well within my rights. The First Amendment was a beautiful thing. I replied to Douglas with a very simple message. The information in the flyer is factually accurate and relates to public safety. As fire chief, I have both the right and the responsibility to provide accurate information to residents. I will not be issuing a retraction. The next few weeks were interesting. The City Public Works Department started repairing the broken hydrants in Meadowbrook Estates, which meant there were work crews and equipment in the neighborhood on a regular basis. Every time a hydrant was being serviced, neighbors would come out and ask questions. Word spread about the maintenance issues, and people started wondering why the HOA had been so focused on landscaping instead of the actual broken infrastructure. My appeal hearing was scheduled for the third Thursday in March. The HOA board meetings were held in the community clubhouse, a nice building near the neighborhood entrance with a meeting room that could seat about 50 people. I arrived at 6:30 for the 7 o'clock meeting, expecting a mostly empty room. Instead, there were at least 60 people already there, with more filing in behind me. I recognized Richard from Oak Hill Drive. There was a woman I'd talked to on the phone named Sandra who'd been fined for flower boxes near a hydrant. Others I didn't know but who apparently knew me. Patricia was at the front of the room, sitting at a table with 4 other board members including Douglas Remington. She looked irritated by the crowd size. The meeting started with standard HOA business. Minutes from the last meeting. Treasurer's report. Discussion about landscaping bids for the common areas. It was all very procedural and boring. Finally, after about 30 minutes, Patricia announced that they would hear appeals. "We have one formal appeal tonight," she said, reading from a paper. Brandon Donovan, 342 Maple Grove Drive, appealing a violation notice regarding hydrant clearance. "Chief Donovan, you have 5 minutes to present your appeal." I stood up and walked to the front of the room. I'd prepared remarks, but looking at the crowd of neighbors who'd shown up, I decided to keep it simple and direct. "My name is Brandon Donovan. I've lived in Meadowbrook Estates for 6 years. I'm also the fire chief for the city of Oakdale. I received a violation notice from the HOA regarding landscaping near the fire hydrant on my property. The notice claimed that I needed to maintain a 15-foot clearance zone. However, the actual fire safety standard, as established by the Oregon Fire Code and used by fire departments across the state, is 3 feet. 3 feet provides adequate space to access the hydrant connections and operate the equipment. Anything beyond that provides no additional safety benefit. I pulled out a printed diagram showing hydrant clearance requirements. This is from the Oregon State Fire Marshal's office, 3 feet, not 15. The HOA covenant states that clearance should be maintained according to fire department standards. I'm the fire chief. I'm telling you what those standards are. My landscaping complies with the actual fire safety requirements. Therefore, the violation notice is invalid. Patricia leaned forward. "Chief Donovan, the board appreciates your expertise, but as we've explained, the HOA has the right to set standards that exceed minimum requirements." "You have the right to set aesthetic standards," I agreed, "but you don't have the right to misrepresent safety standards. You've been telling homeowners that 15 feet is necessary for fire safety. That's false. If you want to require 15 feet of clearance because you think it looks better, that's your prerogative, but don't call it a safety issue when it's not." Douglas Remington spoke up. "Chief Donovan, the covenant is very clear. Homeowners agree to follow HOA rules when they purchase property here. This isn't a matter of fire safety. It's a matter of contract law." "Then change the rule," I said, "because right now you're fining people over a safety standard that doesn't exist." Meanwhile, there were 5 hydrants in this neighborhood that failed inspection. 3 of them were completely non-serviceable. Those are actual fire safety issues, and the board has done nothing to address them. Those are city infrastructure. Patricia said. Not HOA responsibility. But you're claiming authority over fire safety standards, I countered. You can't have it both ways. Either fire safety is your concern, in which case you should be worried about broken hydrants, or it's not your concern, in which case you should stop making up clearance requirements. The crowd murmured in agreement. Several people clapped. Patricia's face flushed. The board will deliberate and provide a decision within 10 business days. Thank you, Chief Donovan. I returned to my seat. Several other homeowners raised their hands to speak during the public comment period. Richard talked about the money he'd spent unnecessarily. Sandra described how Patricia had threatened her with liens over flower boxes. Another man, whose name I didn't catch, pointed out that he'd lived in 3 different HOA communities, and none of them had a 15-foot hydrant clearance requirement. The board looked increasingly uncomfortable as the complaints piled up. Patricia tried to maintain control, insisting that the policies were established for everyone's benefit, and that enforcement was necessary to maintain community standards. Douglas kept citing the covenant and talking about legal obligations. The other 3 board members, who apparently hadn't said much of anything all night, mostly just looked like they wanted to be somewhere else. The meeting finally ended around 9:30. As people filed out, several neighbors came up to thank me for speaking up. Sandra, the woman with the flower boxes, handed me a piece of paper. I've been collecting signatures, she said. We're petitioning to recall the current board and elect new members. We need 20% of homeowners to sign to trigger a special election. We're already at 15%. I can't get involved in HOA politics, I said. Not officially, but I hope you get the signatures you need. We will, Sandra said confidently. Patricia has made a lot of people angry over the past year. This hydrant thing was just the last straw. I drove home feeling cautiously optimistic. The appeal might not go my way, but at least the other homeowners were paying attention now. Sometimes that was all you needed to create change. The board's decision arrived 8 days later via certified mail. They had denied my appeal. The letter, signed by all 5 board members, stated that the HOA's 15-foot clearance requirement was within the board's authority to establish, and that my failure to comply would result in continued daily fines until the violation was corrected. They also added a new twist. The letter informed me that I now owed 14 days of fines totaling $700, and that if I didn't pay within 30 days, the HOA would place a lien on my property. I showed the letter to Rebecca that evening. She read it twice, then set it down on the kitchen table with a heavy sigh. They're actually going to put a lien on our house over ornamental grasses, she said. They're going to try, I said, but liens are tricky. They have to follow specific legal procedures, and there are protections for homeowners. Plus, I'm not going anywhere near done fighting this. What's your next move? I'm going to pay the $700 under protest, I said. That way they can't claim I'm delinquent while I figure out the next step. Then I'm going to talk to a real lawyer, not an HOA board member who happens to have a law degree. The attorney I found was named Catherine Morris. She specialized in HOA disputes and property law. Her office was in Portland, about 40 minutes from Oakdale, but she had an excellent reputation. I explained the entire situation during our first consultation. Catherine listened carefully, taking notes and occasionally asking clarifying questions. When I finished, she sat back and smiled. This is actually a pretty interesting case, she said. The HOA is on shaky legal ground in a few different ways. First, the covenant language is ambiguous. It says clearance should be maintained according to fire department standards, and you are the fire department. Their 15-foot requirement directly contradicts the standard you've established. Second, they're claiming the requirement is for safety, but you've demonstrated that it's not. That could be construed as fraudulent or deceptive enforcement. So I can fight the fines. You can fight them, Catherine confirmed. Whether you'll win depends on a lot of factors, including how the judge interprets the covenant language. But you've got a strong case. The fact that you're a fire safety expert works heavily in your favor. And the fact that they ignored actual safety violations while focusing on aesthetic issues shows their priorities aren't really about safety at all. What's the process? We file a lawsuit against the HOA challenging the fines and the underlying policy. We'll ask for declaratory judgment stating that your landscaping complies with fire safety standards and that the HOA has exceeded its authority. We'll also ask them to refund the $700 you already paid. It'll probably take several months to work through the court system. And in the meantime, don't remove your landscaping. Keep documentation of everything. If they continue to assess fines, pay them under protest and keep records. We want to show that you've acted in good faith throughout this process. I hired Catherine and she filed the lawsuit the following week. The HOA would have to respond within 30 days. 2 days after the lawsuit was filed, I got a call from Patricia. Her voice was tight with barely controlled anger. "Chief Donovan, I've been informed that you're suing the HOA." "That's correct," I said. "This is completely unnecessary. The appeals process exists for a reason. You should have accepted the board's decision." "The appeals process is internal to the HOA," I said. "When I disagree with the outcome, I have the right to seek external review." "That's what the court system is for." "You're wasting everyone's time and money," Patricia said. "The HOA will have to hire attorneys to defend against this frivolous lawsuit. Those costs come out of the community budget, which means everyone's dues go up." "Then drop the fines and change the policy," I suggested. "My attorney says we can file a motion to dismiss if the issue becomes moot. The board will not be bullied into changing established policies. I'm not bullying anyone. I'm asking for a reasonable interpretation of the rules based on actual professional standards. You're the one who chose to make this a legal issue by imposing fines." Patricia hung up without responding. I suspected she wasn't used to people pushing back against her authority. The next few weeks were relatively quiet. The Public Works Department finished repairing all the hydrants in Meadowbrook Estates, which was good. Sandra's petition drive to recall the board gathered enough signatures to trigger a special election, which was scheduled for late May. The HOA hired a law firm out of Portland to defend against my lawsuit, and their initial response argued that the board had broad authority under the covenant to establish safety standards, and that my claim was without merit. Catherine filed a counter-response that was absolutely beautiful. She methodically dismantled every argument the HOA's lawyers had made, citing case law and pointing out the contradictions in their position. She also included declarations from 2 other fire chiefs in Oregon confirming that the standard clearance requirement was 3 feet, not 15. In mid-April, something unexpected happened. I got a call from a reporter named Josh Hamilton at the Oakdale Tribune, the local newspaper. "Chief Donovan, I've heard about your dispute with the Meadowbrook Estates HOA. Would you be willing to talk about it for a story?" I hesitated. I didn't want to come across as someone who ran to the media every time I had a problem. But on the other hand, the situation raised legitimate questions about how HOAs operated and whether they were accountable to anyone. "What angle are you looking at?" I asked. "The balance between HOA authority and professional expertise," Josh said. You're not the first person to have issues with HOA overreach, but you're the first fire chief I've heard of who's pushing back on safety-related rules. I think it's a story people should know about. Let me think about it, I said. Can I call you back tomorrow? I discussed it with Rebecca and with Catherine. Rebecca thought it might help to have public awareness of the issue. Catherine was more cautious, warning that media attention could complicate the legal case, but ultimately said the decision was mine. I called Josh back and agreed to an interview. We met at a coffee shop downtown, and I walked him through the entire situation, from Patricia's first visit to the lawsuit. I was careful to stick to facts and avoid personal attacks. Josh took detailed notes and asked thoughtful questions. Have other homeowners had similar issues with this HOA? He asked. I know of at least a dozen people who have been fined over hydrant clearance, I said. Some of them spent hundreds or thousands of dollars on landscaping changes that weren't necessary. There's actually a recall election coming up because enough people are frustrated with how the board operates. That's good context, Josh said, making another note. One more question. If you win your lawsuit, what happens to the other homeowners who already paid fines or made landscaping changes? I hadn't thought about that. I don't know. I assume they could file their own lawsuits or demands for refunds, but I'm not sure how that would work legally. The article ran on the front page of the Tribune's local section the following Sunday. The headline was, Fire Chief Challenges HOA Over Safety Standards. Josh had done a good job presenting both sides of the issue. He quoted from my interview, but he'd also gotten a statement from Patricia, who insisted that the HOA was acting within its authority and that the lawsuit was a waste of community resources. What really made the article interesting were the comments from other homeowners. Josh had interviewed several people who'd been fined by the HOA, and their stories painted a picture of an organization that was more interested in control than in actual community improvement. One man had been fined for parking his work truck in his own driveway overnight. A woman had been cited because her front door wreath was the wrong shade of red. Another couple had received a violation notice because their lawn was a quarter-inch too tall after they'd been out of town for a week. The article got a lot of attention. It was shared widely on social media, and several Oregon news outlets picked it up and ran their own versions. I started getting emails and calls from people in other HOA communities who'd had similar experiences. A few other fire chiefs reached out to say they'd dealt with comparable situations and appreciated that someone was finally challenging the overreach. Patricia, predictably, was furious. She sent me a cease and desist letter through the HOA's attorneys, claiming that my public statements were defamatory and demanding that I stop talking to the media. Catherine responded with a polite letter explaining that truth was an absolute defense to defamation, and that I had every right to discuss matters of public interest. The recall election took place on a Tuesday evening in late May. The voting was held at the community clubhouse, and turnout was apparently the highest anyone could remember for an HOA election. Sandra had told me that they'd recruited a full slate of 5 candidates to run against the existing board members, all of them homeowners who were fed up with what they saw as excessive enforcement and petty regulations. I didn't attend the vote counting. It felt like it would be too much like gloating if I showed up, but Sandra called me around 9 o'clock with the results. We won, she said, and I could hear the excitement in her voice. All 5 of our candidates won. Patricia got 23% of the vote. Douglas got 18%. The others did even worse. Congratulations, I said. What happens now? The new board is seated immediately. We're having an emergency meeting tomorrow night to review current policies. The hydrant clearance rule is first on the agenda. I appreciate you keeping me informed, I said. But I want to be clear that I can't be involved in board decisions. I need to stay neutral as fire chief. We understand, Sandra said, but we do want to consult with you about fire safety standards as we revise the policies, officially, the way we should have done from the beginning. The new board moved quickly. At their first official meeting, they voted to change the hydrant clearance requirement from 15 feet to 3 feet, in accordance with fire department standards. They also voted to refund any fines that had been collected under the old policy, and to notify homeowners that they were no longer required to maintain the excessive clearance zones. Catherine filed a motion to dismiss my lawsuit as moot, since the issue had been resolved. The judge granted the motion, and the case was closed. The HOA's insurance company ended up paying my legal fees as part of the settlement, which seemed appropriate since they were the ones who'd fought the reasonable resolution in the first place. But here's where things got interesting in a way I hadn't expected. About 2 weeks after the new board took over, Sandra called me with a question. "Brandon, we've been going through the HOA's financial records and we're finding some irregularities, expenses that don't quite add up, payments to vendors that we can't verify. Would you be willing to look at some of this with us? Not as fire chief, just as someone with experience reviewing budgets and documentation." "How irregular are we talking?" I asked. "Potentially tens of thousands of dollars over the past 3 years. I met with Sandra and 2 other new board members, a man named Kevin and a woman named Lisa, at the clubhouse the following evening. They had spread financial documents across the meeting table, bank statements and invoices and payment records. "Show me what you're seeing," I said. Kevin pointed to a series of payments. "These are all made out to a company called Pinnacle Property Services. The invoices say they're for landscaping and maintenance. But we've talked to the actual landscaping crew that works in the neighborhood, and they're paid directly by the HOA. They've never heard of Pinnacle. How much are we talking about total?" $42,000 over 3 years, Lisa said. "Paid in monthly installments of around $1,200. I pulled up the business registration database on my phone. Pinnacle Property Services is registered to a Douglas Remington at an address in Lake Oswego. That's Patricia's friend, right? The board vice president who's also an attorney." "The same," Sandra confirmed. "We think he was billing the HOA for services that were never provided, and Patricia was approving the payments." "That's embezzlement," I said. "You need to contact the police." "We were hoping you'd say that," Kevin said. "We wanted to make sure we weren't overreacting before we went to the authorities." "You're not overreacting. This is serious fraud. The police need to investigate, and you should probably also contact the district attorney's office. HOA board members have a fiduciary duty to the homeowners. If they've been stealing money, that's criminal." The new board filed a report with the Oakdale Police Department the next day. The detective assigned to the case was someone I knew, a guy named Ron Fisher who'd been with the department for about 15 years. "Brandon, this is your HOA?" Ron asked when I ran into him at a city council meeting a few days later. "Unfortunately, yes," I said, "though the board that was allegedly stealing has been voted out." "We're looking into it," Ron said. "The paper trail is pretty clear. Remington created a shell company and billed the HOA for fake services. Patricia Henderson approved all the payments. We're building a case for theft and fraud. How long does something like this take? Depends on how cooperative they are. If they lawyer up and fight, could be months before it goes to trial. If they take a plea deal, could be resolved pretty quickly." The investigation proceeded through June and into July. I stayed out of it as much as possible, but I kept hearing updates from Sandra and other board members. Apparently, the police had discovered that the scheme was even more extensive than initially thought. In addition to the fake property services company, Douglas had also billed the HOA for legal services that were never actually provided. Patricia had approved those payments too. All told, the embezzlement totaled over $60,000. In late July, both Patricia Henderson and Douglas Remington were arrested and charged with multiple counts of theft, fraud, and abuse of fiduciary duty. The local news covered the arrests, and the story got picked up by larger outlets because of the earlier coverage of my lawsuit. The narrative of an HOA president who'd harassed homeowners over petty violations while simultaneously stealing from the community budget was too juicy not to cover. Patricia's arraignment was surprisingly quick. Her attorney negotiated a plea deal. She agreed to plead guilty to 2 counts of theft in exchange for the other charges being dropped. She was sentenced to 2 years of probation, 300 hours of community service, and ordered to pay full restitution of her share of the stolen money. She was also permanently banned from serving on any HOA board in Oregon. Douglas fought the charges initially, but when his attorney saw the evidence, he apparently advised taking a deal. Douglas pleaded guilty to fraud and theft and received a similar sentence, though his restitution amount was higher since he'd been the primary beneficiary of the scheme. By August, life in Meadowbrook Estates had settled into a new normal. The new HOA board was functioning well, focused on actual community improvement rather than petty enforcement. The hydrant clearance rule was now reasonable and based on actual safety standards. Several homeowners who'd spent money on unnecessary landscaping changes were compensated from the recovered funds. I was sitting on my back deck one Saturday morning in mid-August, drinking coffee and reading the paper, when Rebecca came outside with her own cup. "So it's finally over?" she asked, settling into the chair next to mine. "I think so," I said. "The new board seems to have things under control. The criminal cases are resolved. My landscaping is exactly as it should be. Life is good." Did you ever imagine when Patricia showed up at the door that first morning that it would turn into all of this? Not even remotely, I admitted. I thought it would be a minor annoyance. Fill out some paperwork, maybe go to a board meeting, done. I never expected to find embezzlement. "You probably made some enemies, though," Rebecca said. "Patricia and Douglas, sure. But I think most of the neighbors appreciate that someone stood up to the nonsense. And honestly, if standing up for reasonable standards and professional expertise makes me an enemy to people like that, I'm okay with it." Rebecca raised her coffee mug. "To being okay with it." I clinked my mug against hers. "To being okay with it." The following Thursday, I was at the fire station doing paperwork when I got a call from Sandra. "Brandon, I wanted to give you a heads up about something," she said. "The board voted last night to name the small park near the community entrance Donovan Park in recognition of your efforts to improve fire safety in the neighborhood and for standing up to the previous board." I was genuinely speechless for a moment. "Sandra, that's not necessary." "We know it's not necessary. We want to do it. You didn't have to fight this fight. You could have just removed your landscaping and paid the fines and moved on. Instead, you challenged an unfair policy, exposed corruption, and helped create real change in the community. That deserves recognition." "I'm honored," I said. "Truly. But I was mostly just irritated about ornamental grasses." Sandra laughed. "Sometimes the best activism starts with personal irritation. The park naming will be official at next month's board meeting. We'd love for you to be there." I attended the board meeting in September. It was a much different atmosphere than the contentious meeting where I'd presented my appeal. The room was maybe half full, and people were friendly and relaxed. The new board worked through their agenda efficiently, discussing actual community issues like playground equipment maintenance and plans for a neighborhood block party. When they got to the park naming item, Sandra gave a short speech about the importance of challenging unjust rules and standing up for what's right, even when it's inconvenient. She thanked me for my service as fire chief and for helping to reform the HOA's approach to fire safety. "It's a small park," Sandra said, "but it represents something important. It represents the principle that expertise matters, that professional standards exist for good reasons, and that no organization, no matter how much authority it thinks it has, should prioritize control over common sense." "We're proud to name it Donovan Park." People applauded. I stood up and said a few words of thanks, keeping it brief because I'm not great with emotional speeches. But I meant every word. The entire experience had been frustrating and time-consuming and occasionally infuriating. But it had also been a reminder that local democracy still worked when people paid attention and stood up for themselves. After the meeting, several neighbors came up to congratulate me and share their own stories about dealing with the old board. One man told me he'd been fighting a violation notice about his fence height for 8 months before the recall election resolved the issue. A woman mentioned that Patricia had tried to fine her for having a political yard sign during the election season, which was actually illegal under Oregon law, but Patricia had done it anyway. "You opened the door for all of us to push back," the woman said. "Before you filed your lawsuit, most of us just assumed we had to go along with whatever the board said. You showed us we had rights." Driving home that night, I thought about what she'd said. It was true that most people, when confronted with bureaucratic authority, just assume they have to comply. HOA, in particular, operated in this weird space where they had real power but minimal oversight. They could fine people, place liens on property, and make life miserable for anyone who didn't follow their rules, no matter how arbitrary those rules were. Most homeowners just paid the fines and moved on because fighting seemed too difficult or too expensive. But the thing about authority is that it's only as strong as people's willingness to accept it. Patricia had operated for years on the assumption that nobody would seriously challenge her. She made up rules, imposed fines, and wielded the HOA covenant like a weapon. And most people just took it because they didn't know they had options. When someone finally did challenge her, when someone with actual expertise and the willingness to fight pushed back, the whole facade crumbled pretty quickly. And once the facade crumbled, people started looking closer. They started asking questions about finances and policies, and whether the board was actually serving the community's interests. That scrutiny revealed the embezzlement, which might have continued indefinitely if everyone had just kept their heads down and paid their fines. I pulled into my driveway and looked at the fire hydrant at the corner of my property. The ornamental grasses around it were looking good, full and green in the late summer warmth. They provided nice color and texture, they required minimal maintenance, and they didn't interfere with the hydrant at all. Exactly as they should be. Rebecca was already home. I found her in the kitchen making dinner. "How was the meeting?" she asked. "Good," I said. They officially named the park. People were nice. It was a good night, and Patricia didn't show up. I assume she's moved on with her life. Do you think she learned anything from all this? I considered the question. Probably not. People like that usually don't. They convinced themselves they were right, and everyone else just didn't understand. But it doesn't really matter what she learned. What matters is that the other homeowners learned they don't have to accept unreasonable authority just because someone claims to have it. That's very philosophical, Rebecca said, smiling. I have my moments. The months that followed were remarkably uneventful, at least as far as HOA drama was concerned. The new board continued to operate efficiently and reasonably. They updated several outdated policies, improved communication with homeowners, and generally acted like people who understood they were serving the community rather than ruling over it. In November, the restitution payments from Patricia and Douglas started coming through. The board decided to use the recovered funds to make several improvements to the community, including upgrading the playground equipment and installing better lighting along the walking paths. They also set aside money to refund homeowners who'd been fined under unjust policies or had paid for unnecessary modifications. I received a check for $700, a refund of the fines I'd paid under protest. I used it to take Rebecca out to a very nice dinner in Portland and donated the rest to the local fire safety education program. By December, the whole experience had faded into memory, just another story to tell at parties or when people asked about HOA life. I'd learned some things about property law and covenant interpretation. I'd learned that standing up for reasonable standards sometimes required more effort than just going along with unreasonable ones. And I'd learned that local democracy, for all its flaws and frustrations, still worked when people cared enough to participate. The fire hydrants in Meadowbrook Estates remained properly maintained. The clearance zones remained at 3 feet, based on actual fire safety standards determined by actual fire safety professionals. And life went on, as it always does, with new challenges and new problems to solve, but without Patricia Henderson demanding compliance with arbitrary rules she'd invented. On Christmas Eve, Sandra stopped by with a small wrapped package. "Merry Christmas," she said. "This is from the board." I opened it to find a framed photograph of Donovan Park, taken on a sunny afternoon with kids playing on the equipment and families having picnics. At the bottom was a small plaque that read, "In recognition of standing up for what's right, even when it's inconvenient. Meadowbrook Estates Community, 2025-2026. "This is really nice," I said. Thank you, Sandra replied. "You made this community better. That's worth recognizing." After she left, I showed the photo to Rebecca. We decided to hang it in my home office, right next to my fire chief certification and my college diploma. It seemed appropriate. Those other documents represented formal education and professional achievement. This one represented something different but equally important: the willingness to challenge authority when authority was wrong. As I hung the frame on the wall, I thought about how the whole situation could have gone differently. I could have just removed the landscaping. I could have paid the fines without protest. I could have accepted Patricia's interpretation of the rules and moved on with my life. It would have been easier. It would have been faster. It would have avoided months of stress and conflict and legal fees. But it also would have been wrong. Not wrong in any dramatic or life-altering way, but wrong in the quiet, corrosive way that accepting petty injustice always is. It would have reinforced the idea that people with a little bit of power can make up rules without justification and enforce them without accountability. It would have left Patricia and Douglas free to continue their embezzlement scheme. It would have left dozens of other homeowners paying fines and making expensive changes to their properties for no legitimate reason. Sometimes the most important fights are the ones that seem petty from the outside. A dispute over ornamental grasses near a fire hydrant doesn't sound like it matters much in the grand scheme of things. But it mattered to the homeowners who were being fined unjustly. It mattered to the integrity of fire safety standards. It mattered to the principle that expertise and professional judgment should count for something when making decisions about technical issues. And it turned out to matter even more than that, because standing up to one form of abuse revealed another, more serious form. The hydrant clearance dispute was just the visible symptom of a deeper problem, a board that had stopped serving the community and started serving itself. Challenging the symptom exposed the disease. I stepped back and looked at the photo on the wall. A small park in a suburban HOA community, named for a person who'd simply insisted that rules should make sense. It wasn't heroic. It wasn't dramatic. It was just someone doing what shall